Okay, I may have come back a little bit early, but when we get Ms. Dent, we'll get started.
I'm here, Your Honor.
Great. And we got Ms. Mosley. Wait for her as well. There we go. Okay, the court's back on the record in the Mosley matter. We're Ms. Pierce is you're calling Mr. Jeffries. Is that correct, Ms. Pierce?
That's correct, Your Honor.
Mr. Jeffries, if you would please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Ms. Pierce, you may proceed.
Can you state your name for the court?
Bruce Jeffries,
And how are you employed?
National Screening Center, National Assessment Center. I'm the owner, 29 years.
Your Honor, the court ordered these parties to drug test in September, and those results have come back, and I'd like to offer P1 and P2 into evidence.
Any objection to P1?
No, no.
and P2?
No objection, Your Honor.
P1 and P2 are admitted.
May I share the screen, Your Honor?
You may.
Oh, it says you disabled it.
I just enabled it when you
Oh,
asked.
okay, thank you. Okay, great. Wait, not that one. Well, I'm going to show you what's been marked as P2, Mr. Jeffries. And can you tell me what this is?
Yes, ma'am. That is a final result from Quest Diagnostics out of Lenexa, Kansas, that's been certified. This is a hair test taken from the head. Test code is 370009. This is an ingestion test only. We are not looking for exposure on the outside of the head.
And who is the person that this test result represents?
Casey Mosley appeared at our office on 9/21/2021.
And I'm sorry, I'm trying to get the other one. I realized I didn't open. Can you tell me what the results were for Miss Mosley's drug screen?
Quest Diagnostics did not find any metabolite present, and the drugs listed on your screen is what was tested. This is a negative test.
Okay. I'd like to show you P1. If I can find it. Oh, let me stop that a second. I'm sorry, I have to stop sharing. I'll figure this out about the time we get back to court. So can you identify for the record what P1 is?
Yes, ma'am. My answer would be the same. It's a test from Quest Diagnostics out of Lenexa, Kansas. It was a hair test. Due to no hair on the head, we had to go to a body part, so we shaved his arm. And the same test code 370009 is an ingestion test only, with no exposure was tested on the outside of the hair.
And who is this test for?
Jerry Mosley.
I'd like to ask you to tell me what the results of his test were.
It's a two-tier test. The first bank of numbers you see that says initial test level is a machine called a Tecum Clinical Analyzer with ELISA plates. The raw data came out of that first machine. It was reviewed by 3 certifying scientists. They all determined that marijuana was present on the first run. It then goes to the second bank of numbers, which is performed by a gas chromatograph, mass spectrometry. The raw data then appeared, and it was reviewed by 3 certifying scientists. They signed off on it. The quantitative result that was confirmed as a positive is a marijuana at 15.3 picograms per milligram.
And can you explain for the court what 15.3 picograms means?
Sure. So if you look on the right side, the bank of numbers, the confirmed level is anything over 0.1 would be deemed positive. So it goes from 0.1 all the way to 0.9, flips over to 1, and of course 1.1 and up to 1.9, then to 2, and so on and so forth till it hit 15. And the final result was 15.3. That is an extremely high level. That would be somebody that has had THC in their body on a chronic basis.
Would you consider this a low amount for a marijuana strain?
Absolutely not.
Could this level of marijuana metabolite or what it would require a person to get to this level, could that ever render a person unconscious?
It depends. You know, we've had data sent to us from the lab and CDC and the Food and Drug Administration that due to today's times, the results of the DNA being tampered with at marijuana laboratories has risen. In the 1970s, your marijuana THC tetrahydrocarbonol values were anywhere from between 3 and 5%. They've now reached a threshold of in the 90s. So we're looking at a whole different realm of marijuana in today's times. And there has been deaths occurred as far as motor vehicle accidents. California has seen more deaths due to marijuana than alcohol in the history of drug testing.
Your Honor, I'm going to object as the unresponsive.
Sustain.
Is there any way that this could be considered a medically therapeutic amount of THC?
I've never seen it being at 15.3. There would have to be Marinol or a prescription from a doctor presented after the test is run in order to confirm that there is a medication involved as far as medical marijuana. We have not seen that.
Is medical marijuana available in Texas?
It is.
Okay, and at what levels do you know?
What levels?
Like, I mean, is there a limit? Can you tell if someone is abusing marijuana based on a prescription?
Yes, ma'am. We sent it to a special laboratory called El Soli Laboratories, and they quantify it also.
Your Honor, I'm going to object as Mr. Jeffries having no personal knowledge of the question, of the answer to the question.
Overruled. You may continue, Mr. Jeffers.
So we send that to El Soli Laboratories, a specialized laboratory that deals with marijuana quantification, and they can determine whether or not it's therapeutic or non-therapeutic. Even though I've been in this industry for 29 years, I've never seen a medical review done.
Your Honor, as the unresponsive.
Overruled.
I've never seen a medical review done on medical marijuana that would reach this threshold of 15.3.
So to have this threshold, when you say, can you tell the court what chronic it means? Does that mean daily?
Yes, ma'am.
I'll pass this witness.
Ms. Dent, your witness.
Hey, Mr. Jeffries, do you have any information of any type of levels that was in Mr. Mosley's body on 3/21/21, March 21, 2021?
This test will travel back 4 to 6 months in use. So it could travel back to around March. It's, we take a solid, we melt it to a liquid. So we give you a time frame.
Okay, thank you, Mr. Jeffries. You also said you took hair because there was no
Yes.
hair on the head. You took body hair,
Correct.
and it can go back, you said, up to at least 6 months.
4 to 6 months. Yes, ma'am.
Okay, the test that was administered, is there any way of knowing exactly when there was usage?
No, ma'am.
Did the test tell you that?
No, ma'am. It's just a time frame. We take a solid, melt it to a liquid.
Okay. That's all I have, Your Honor.
Ms. Pearson, your redirect.
I just have one question. There is it correct? There's a test that can go back by section to tell how much a person was using at a certain time. Is that correct?
Yes, that's correct. But on Mr. Mosley, being that he's bald headed, we would not be able to run a dissection test on his body. Oh, you know, you've got to be able to have hair like, for instance, your hair. We could dissect your hair at 30-day increments because you have plenty of hair on your
You're
head.
gonna have to object as the unresponsive after no.
Sustain.
That's all I have of this witness, Your Honor.
Ms. Dent, any further questions of this witness?
Just for clarification, there was no specific test done on Mr. Mosley to suggest specifically when the levels were used in his body.
It's impossible to do that, ma'am.
Thank you. That's all I have, Your Honor, for this witness.
Ms. Pierce, anything further?
Nothing further with Mr. Jeffries.
May this witness be excused, Ms. Pierce?
Yes.
Ms. Dent?
Yes, Your Honor.
Thank you, Mr. Jeffries, for appearing.
Yes, sir, Judge Bell. Have a good day.
You too. Ms. Pierce, you may call your next witness.
Can I call Matthew first so I can let him go too?
Okay. All right, Mr. First, if you would please unmute, and we're going to go ahead and get you called as a witness. Ms. Pierce, you may proceed.
Thank you, Your Honor. Can you state your name for the record?
Matthew First.
And how do you know the parties in this case, Mr. First?
I was a former CPS worker on the case.
And do you know where Mr. Mosley lives?
I don't have his address.
Who do you work for now?
Child Advocates in Houston.
Okay, and who were you working for in March of 2021?
Texas Department of Family and Protective Services in Rosenberg.
And can you tell me how this family came to your attention?
I received an intake for the daughter because father was found passed out at a park during his visit.
And what did the department do as a result of that? And actually, well, I guess never mind. As a result of that intake, what did the department do?
We initiated an investigation and attempted to put a safety plan in place so that the child could stay with the mother while we continued our investigation.
And were you able to put a safety plan in place?
We did ask mom to do whatever she needed to do to keep her daughter safe.
And did the department ask Mr. Mosley to participate in any services?
We tried to get him involved in some sort of substance abuse services, yes.
And did he participate at all with the department?
No.
Did you ever have any interaction with him where you felt like he was under the influence?
Yes.
And what caused you to think he was under the influence?
A series of 10 to 20 phone calls within an hour of being screamed at and then threatening text messages.
Did you ask him at that time to take a drug test?
He had already taken a drug test.
Okay. And what kind of test was that?
I believe it was a urinalysis test.
Right. Okay. And do you remember when y'all closed the case?
Yes.
And why did y'all close the case?
Because the child was safe with the mother and the father was not participating further with us in any services.
And did you give any instructions to the mother um, what she was expected to do to be protective of the child?
We told her to do whatever that she thought necessary to keep her child safe until the father could show that, he had worked services and can continue visit safely with his daughter.
Do you believe that he was capable of properly taking care of Riley when you closed this case?
Not at that time, no.
I'll pass this witness.
Ms. Dent? your
Mr.
witness.
First, I'm sorry, Your Honor. Mr. First, you said when speaking with Mr. Mosley, he was really upset. Is that correct?
I said that he was threatening and calling a bunch of times.
Right. Isn't it true that he had a belief that you were having a relationship with Miss Mosley?
Yeah, that and a lot of other things.
Okay. So it wasn't just out of the blue. That was the reason he was upset. He even reported it to your supervisor. Is that correct? I'm not saying whether it's true or not. I'm just asking.
I reported it to my supervisor.
Are you aware that Mr. Mosley reported to your supervisor as well?
I am aware that he asked for her
Okay,
number.
thank you. Okay, in your affidavit, it is Exhibit B that you wrote. Are you recall that?
Yes,
Petitioner supporting affidavit. Okay, in your affidavit, you state that Mr. Mosley was found unconscious in a public park during the visitation of his daughter.
correct.
That's what you wrote. In that
Correct.
affidavit, you didn't write that he was passed out, did you?
Unconscious, passed out, correct.
My question was, in your affidavit, you did not state that he was passed out.
No,
Okay. You weren't obviously not there in the park, correct?
correct.
How many times did you go to Mr. Mosley's home?
I never went to Mr. Mosley's home.
You said you did an investigation.
Correct.
Usually during your investigations with Texas Department of Family and Protective Services, do you go to both parties' homes to make a
He
complete
was
evaluation?
visited. He was visited by a courtesy worker because he lived out of county.
My question is, did you at any time go to Mr. Mosley's home?
No,
So your investigation did not include having a conversation with Mr. Mosley at his home or checking out the environment where the child would be living?
that's not part of my job at my investigation.
So did you speak with Miss Mosley?
Yes,
Did you go to her home?
yes,
So going to Miss Mosley's home was part of your investigation, but not going to Mr. Ryan's home, is that correct?
correct.
And that's done to make an unbiased opinion?
That's done when one party lives in the county and the other party lives out of the county.
On your affidavit, you state that he was found unconscious. Was there a police report done, do you know?
To my knowledge, yes.
Okay, was Mr. Mosley arrested at that time, to your knowledge?
No,
Was he charged with anything at that time, to your knowledge?
nope,
And the police did come out. Is that correct?
yes.
And are you aware that he took a breathalyzer test at that time?
I'm not aware.
Okay, he did. Are you aware that?
Objection to the sidebar, Your Honor.
Sustained, no sidebars.
I'd ask the court to strike the attorney's comment.
It will be struck.
At any time during your investigation, did you meet with Mr. Mosley personally?
No,
Did you complete an assessment or write an assessment based on your investigation?
no,
You stated that he would not comply with services. Did you ask him to contact the Cradle Project?
correct.
And isn't it true that the Cradle Project needed certain forms from you?
Yes,
And isn't it true that you never got those forms to the Cradle Project?
there was back and forth between all of us.
Okay, Mr. First, my question is, isn't it true that you never provided Cradle Project with the forms that they requested?
That's not to my knowledge, no.
So you sent over the requested forms to Cradle Project and they have those forms.
I was in contact with the Cradle Project, getting him what he needed for them.
Objection, Your Honor, is non-responsive.
Sustain.
My question is, Mr. First, the Cradle Project needed certain forms. Did you send those forms over to the Cradle Project?
Yes.
And when did you send those over to them?
At the time when we were talking, I don't have the exact date.
And what form did you send?
I don't have the exact form.
So you're telling the court that you sent the forms, but you do not know which forms were sent over?
Yes.
Would it surprise you that the Cradle Project didn't have the requested form, so Mr. Mosley could not move forward?
Objection assumes facts not in evidence.
Sustain.
You say in your affidavit the father also failed to give names for supervisors. Is that correct?
I'm sorry?
In your affidavit, your petitioner supporting affidavit, Exhibit B, you state that he failed to give you names for a supervisor. Is that correct?
I'm not sure what you're asking. A supervisor of what?
For visitation?
Oh, yes, correct. No, he gave somebody that was not agreed upon.
Right. Now, who was doing the agreeing upon?
This was an agreement we asked for all parties to agree to.
Right. So the names that Mr. Mosley gave you, those were being forwarded to whom to agree to?
Up to mom.
Did mom agree to any of the names? He sent you at least 4 or 5. Did she agree to any of them?
Objection assumes facts not in evidence.
Sustain.
Did mom agree to any names that you were provided?
There was names that we discussed, yes.
My question was, did mom agree to any names that were provided to her?
I don't recall the names that you're asking about.
My question is not the names of the people. My question is the names that Mr. Mosley provided to you. Did mom agree to any of those names?
I can't answer that question.
Well, if she had agreed to the names, would that person have been the supervisor?
Yes.
Okay, so she didn't agree to the names that Mr. Mosley sent over to you.
I don't recall the names that were sent to me.
Okay, I'm not asking you to recall the names. I'm asking whether or not Ms. Mosley agreed.
I can't answer something I don't remember the names of.
You said that you had a safety plan. You have a current safety plan that's signed by the petitioner and Mr. Mosley?
Do I have a current one?
The safety plan, during your investigation, you said a safety plan was developed. Is that right?
Correct.
Was it in writing?
Yes.
And was a copy given to Mr. Mosley?
I don't think so.
And how was Mr. Mosley to know what the safety plan was if he was not given a copy of it?
The safety plan was created with the parent that had the child with them at the time.
My question is, how was Mr. Mosley to know what the safety plan was or what he needed to do?
It was verbally explained to him.
Let me
Hold
finish,
on,
please.
hold on, Mr. First. Make sure, because there's a record taking down everything that everybody says. So make sure, even though you may anticipate what the lawyer is asking you, let her finish her question before you start to give an answer so that we get a good record, and it helps me as a judge follow the testimony. All right, Ms. Dent.
Yes, Judge.
Thank you, Your Honor. If Mr. Mosley was not giving a copy of a safety plan, how was Mr. Mosley to know what he was supposed to do?
It could have been verbalized to him.
Who was it verbalized by?
Would be verbalized by me or the courtesy worker.
Okay, so you told Mr. Mosley what the safety plan entailed that you gave Ms. Mosley?
I don't recall telling him that, no.
Okay, so he had no way of knowing. Does the Texas Department of Family and Protective Services usually send out like a closing letter at the end of the investigations?
Usually, yes.
Okay. Your Honor, I don't know how to share the screen. My exhibit number 1.
Yeah, I've got the exhibits in front of me. So if you need to share the screen, you have permission to do so. But if you don't want to, that's fine. I can follow the testimony because I have it in front of me.
Okay, Mr. First. The Texas Department of Family and Protective Services sent out a letter to Mr. Mosley. Are you aware?
I'm assuming they did.
Okay, this letter was dated 5/3 of 2021.
Your Honor, I'm going to object to counsel questioning about a document not admitted into evidence.
I think she's trying to lay her predicate, so I'll overrule. You may answer that, sir.
In the letter, you said, I'm sorry, Your Honor, you said your answer to my first question was Texas Department of Family and Protective Services usually sends out a closing letter.
Yes.
My next question was, are you aware, do you know if Mr. Mosley received such a letter?
I don't know if he received it.
Okay, but usually in that letter, the Texas Department of Family and Protective Services will say whether or not your case has been closed or what came of the investigation. Is that a fair statement?
That's a fair statement.
And you do send out those letters as well, or you did when you were employed. Is that correct?
Correct. They usually go through the admin.
Okay, if a person received a letter that said the case was closed with no further action, what would that mean?
It would just mean our investigation was closed.
Would there be anything else that the person would need to do after receiving that letter?
Not coming from us, no.
Okay, if they received a letter that said it was closed with no further action, would that letter inform that there was a safety plan in place?
Objection to counsel reading from a document not admitted into evidence.
I'm asking a
Ooh.
question. My question, Mr. First, my question was, if the person received a letter stating that the case was closed, would that infer that there was a safety plan in place?
No.
If they also received that same letter, would they have any way of knowing that the other party received a safety plan?
No.
I pass this witness, Your Honor.
Ms. Pierce?
Do you still have access to CPS files for you to review?
No, I don't.
And how long have you been, how long ago did you leave CPS?
About 4 months.
Okay, so you haven't been able to review some of the documents that she's been requesting of you for at least 4 months. Is that an accurate statement?
Correct.
That's all I have of this witness, Your Honor.
Ms. Dent, anything further from Mr. First?
Right, Mr. First, you knew you were coming to court. Is that right?
Correct.
Okay, that's all I have, Your Honor.
Ms. Pierce, anything further?
No, Your Honor.
All right, thank you, Mr. First, for appearing. Appreciate it. You're excused.
Thank you.
Ms. Pierce, you may call your next witness.
I'd like to call Casey Mosley.
You may proceed.
Can you please state your name for the court?
Casey Mosley.
And how are you related to, are we supposed to use initials or can we use the child's name, Your Honor?
You can use the child's name.
Okay, how are you related to Riley?
I'm her mother.
And was Mr. Mosley's access to the child restricted at any time?
CPS recommended that he only be provided supervised visitation. Excuse me.
And when was that?
The initial CPS investigation started in March of 2021.
And when did it end?
CPS stopped their active investigation in May, I believe it was, with a recommendation to me stating that Mr. Mosley.
Objection as to non-responsive after it ended in May.
Sustained.
Were you given any instructions when their investigation ended?
Yes, I was advised that she should not see her father unsupervised because he had not completed the recommendations CPS had put in place.
Did CPS put any restrictions on you?
No, ma'am.
Do you know where Mr. Mosley is living?
I have a general idea. I know where the apartment complex is because when he was receiving visitation, I did facilitate that by taking her over there. but he has never provided me with an apartment number. He would always just come to the front gate. Hence the reason service was difficult.
Does he live with anyone?
Jeremy Long.
Do you have any concerns about his living situation as it pertains to your daughter's visits?
Yes.
Okay, and what are those?
There's a long standing history of drug abuse amongst him as well as Mr. Long. Mr. Long also has a history of domestic violence.
Objection
And-
is relevance, Your Honor.
So what was the objection?
Relevance.
Overruled.
And what, you said he has a history of domestic violence. Is that against adults, children?
It was against a child. It was against his ex. I don't know if they were married or not, ex-wife or girlfriend. He fractured her son's arm.
And how long ago was that?
In a ballpark, 5 years.
Now, was he one of the people suggested to be a supervisor?
Yes.
Do you have concerns about Riley's safety when she's with her dad?
Yes.
And why is that?
Again, a longstanding history of drug abuse. Upon CPS's investigation, his drug test was positive, hence the reason for the safety plan. His drug test continues to be positive. There's also, even via telephone, lots of verbal, I don't know if abuse is the proper word to use, lots of screaming, yelling, cursing, threatening. You know, even as recently as this weekend, or actually even as recently as yesterday, he tells her she's not allowed to stay in the same room that I am in when he's talking to her, so that I can't hear what he's saying to her.
Objection, Your Honor, is unresponsive and narrative.
Sustained.
What type of things does he say to the child that you've heard him say?
As recently as Sunday, he was screaming that because she did not call him the night before, that, can I say the actual words? That it was fucking bullshit, that he was tired of her doing this motherfucking shit to him, that it was bad enough that her mother was already keeping her from him, and now she wouldn't even call him at bedtime. She's 8. Like, on a Saturday night, if she's hanging out with friends, she's not gonna call dad.
Objection, Your Honor, as to unresponsive and narrative.
Sustained to the very end there.
Are you asking the court to order supervised visitation at this time?
Yes.
Do you know anyone that you would approve to monitor his visits that would be willing to do it?
As far as his associates or mine?
No, either somebody that, okay, yes, anybody that you would, I don't know if they would agree to it, but who would you agree to?
I would agree to my mother,
What is her name?
Lee Holt, to my best friend, Amy Frazier. I would agree. So I would agree to his brother in that I have a good relationship with his brother. They do not have a good relationship, so I don't know that his brother would agree. And I know that historically he has asked his brother to lie and say that he was supervising, but not actually do it. And that was his brother's concern.
If none of these people can be agreed to, are you requesting an agency monitor those visits?
Yes.
Now, since he is in Harris County, I believe he would be available to use the Harris County Domestic Relations Office for visitation, which last I knew they had a grant, so the visitation wasn't even costing anything, but you would of course have to take the child to the visit. Do you have a problem doing that?
No.
Have you offered him other opportunities for supervised visit in this interim from May to now?
Repeatedly. I've told him that I would meet him at a restaurant, that I would sit at a separate table and they could have dinner and visit. I did state that my mother and my stepfather would go with me because I don't feel safe going alone, but that we would go and sit at a separate table and allow them to visit for as long as they wanted to. And he's declined that every time I've offered.
Does he have a vehicle?
He does not have a vehicle. I believe it was impounded when he got his last DUI.
Do you know how long ago the DUI was?
Approximately 2 years ago. It was in West Texas.
So does he have a valid Texas driver's license?
He does not. I don't think he can get one due to non-payment of child support.
Objection, Your Honor, is non-responsive.
Sustain.
How long since he's paid any child support?
How long have we been divorced? His
Objection, Your Honor, is a non-responsive. Ask that the comment be stricken from the record.
Sustain. Ma'am, just answer the question that's asked. How long has it been since he paid child support? If you know.
he does not pay child support. He's never consistently paid. The OAG is involved.
Should he be driving Riley around?
He doesn't. He has a suspended driver's license.
The judge ordered Mr. Mosley to have video access with the child nightly at 6 at the last hearing. Do you remember that?
Yes, ma'am.
How has that been going?
Well, he doesn't follow that guideline. He calls it all hours of the day and night. And depending on his mood, sometimes they have a pleasant conversation. Sometimes he screams at her. I believe that the last attempt at contact, he called her at 10:18 last night, but it was a school night, so she had long since been in bed.
Are you concerned about the daily phone contact continuing?
If he continues to not follow the order and just, like I said, calls at all hours of the day and night and then screams at her if she doesn't answer or respond to him, even if those phone calls occur at an inappropriate time, like 10:18 on a Tuesday night. And I also do not agree. He has told her on more than one occasion.
Objection, Your Honor, is a non-responsive.
Sustain.
Okay, what other concerns do you have?
He's told her that she cannot be in the same room with me when he converses with her. And I don't see why she can't sit next to me on the couch while she's talking to her dad. That concerns me as to what's being said.
What's your child's demeanor after talking to her father?
If they have a good conversation, it's good. If they have a conversation like the one on Sunday, then it's very tearful and frightened.
Excuse me, before the incident in March, how consistent were his visits?
As long as I facilitated them, they were consistent. So as long as I was willing to do all of the drop off and the pickup, and then they were consistent.
And are you ordered to do that?
No, I've done it just to help him out.
Are you requesting that prior to him returning to the standard possession order that he be able to provide a clean hair follicle test?
Yes, hair follicle and urine.
You're aware urine only goes back 3 days. Are you aware of that?
Yes, that's why I would request both to see. I mean, obviously his hair follicle test was not clean this time, but I would like to see, when CPS did theirs, they did a urine that was positive in the immediate after the incident in March.
And if the judge orders any drug tests in the future, is there any particular place you would like them to be done?
National Screening Center.
And is there a reason for that?
I feel like there's a history of trying to work around the system there, like in this test where he went to the wrong location at the wrong time and et cetera, and
Okay, are you referring to him trying to get tested somewhere other than national screening?
yes, with this ordered test.
Okay. I'll pass this witness.
Ms. Dent, your witness.
Thank you, Your Honor. Ms. Mosley, you have a signed safety plan from CPS,
Yes, ma'am.
and it has Mr. Mosley's signature on it as well?
They did their investigation.
Yes or no? Yes or no, please.
Same.
I'm not sure.
You have a safety plan, but you're not sure if Mr. Mosley's name is on it? Is
I
that
have a
what you're
safety
saying?
plan that was communicated to me. I'm not sure what was communicated to him.
My question is, do you have a safety plan in writing from the Texas Department of Family and Protective Services?
Yes, I have what was communicated to me.
Is that a yes as to in writing?
Yes, I have what was communicated to me.
Your Honor, I'm going to object as a non-responsive.
Sustained after yes.
In the writing, in your safety plan from Texas Department of Family and Protective Services, does it have Mr. Mosley's signature on that document?
No, we had two different investigators.
The answer is no. Ms. Mosley?
We had two different investigators.
You state in your affidavit, which has been submitted to the court in Exhibit C, that you were contacted by Child Protective Services because Mr. Mosley was found in the park. Is that correct?
I was actually contacted by HPD. I had to pick my child up.
Okay, so you were contacted that he was in the park. Is that right?
Correct.
On that day, do you know if Mr. Mosley was arrested for being intoxicated or on drugs?
I was told he was released.
Yes
Oh,
or
yes,
no?
I was told he was intoxicated. Yes. And I was told he was released to a friend who was also intoxicated.
I'm going to object, Your Honor, as a non-responsive.
Sustained. Hold on, Ms. Mosley. Ms. Pierce is going to get an opportunity to ask you questions again. If she thinks that you're getting boxed in a corner and you're not getting to explain your answers, she's a good lawyer. She will give you an opportunity to elaborate on those kinds of answers. But right now, I need you to focus on just answering the question that's asked. Ms. Dent is allowed to lead you, so she may ask you questions that call for a yes or no response. I don't need an explanation. I just need you to answer her questions, and Ms. Pierce will let you explain later if you need to. All right, Ms. Dent, you may proceed.
Thank you, Your Honor. Was Mr. Ryan charged with anything on that day?
Not that I'm
Objection
aware.
calls for speculation.
If you know.
Sustained.
Was Mr. Ryan charged with anything on that day, if you know, Ms. Mosley?
I don't know.
Are you aware that Mr. Mosley took a breathalyzer on that day?
No, I'm not.
So you don't have any actual knowledge of whether or not there was any type of foreign substance in Mr. Mosley's body on that day. Is that correct?
Correct. I only have what law enforcement told me.
Yeah. Objection as a non-responsive after
And
correct,
after
Your
correct.
Honor.
Sustained after correct.
Are you aware that Mr. First instructed Mr. Mosley to contact the Cradle Project?
Yes.
Or do you know whether or not Mr. Mosley contacted the Cradle Project?
No.
Are you aware that the Cradle Project needed some documents from Mr. First in order to proceed?
No.
Are you aware that Mr. First failed to provide those documents to the Cradle program so Mr. Mosley could proceed?
No.
Objection seems facts, not in evidence.
Overruled.
I didn't hear your answer, Ms. Mosley.
No.
Their affidavit states that CPS closed their case. Did you receive a closing letter from the Texas Department of Family and Protective Services?
Yes.
And in that closing letter, it stipulated that you should be protective of the child and Mr. Mosley should have supervised visitation?
Yes.
And who did that letter come from?
The Department of Family and Protective Services.
When was that letter dated?
The form letter that I received would have been the same date. I don't have possession of it. May.
So you have the letter, the closing letter from Texas Department of Family and Protective Services, obviously to show the court, that says that you should be protective and not let Mr. Mosley have any visits with the child? Do you have that?
No, that was in the previous plan.
So my question
Hold on,
is,
just
let's,
1 second. I'm sorry for the interruption, but her video locked up for the court, so the record didn't get it and I didn't get her answer. What was the answer to that? Do you have a letter from Department of Family and Protective Services that says dad should only have supervised visitation?
That was in the previous plan.
I'm gonna object as a non-responsive to my question, Your Honor.
Dane,
Ms. Mosley, my question is, do you have, you said you received a closing letter from the Texas Department of Family and Protective Services, correct? Yes or no?
Correct.
Okay, in that letter that you received from the Texas Department of Family and Protective Services, does it say that you should be protective and dad should only have supervised visitations with the child?
Not in that letter.
Okay, so the answer is no. Is that correct?
I think I just answered that. Not in that letter.
Your Honor, I'm going to object as a non-responsive.
I think it means no. I understand, but ma'am, Ms. Mosley, just answer the question that's asked. It's going to make this proceeding go a lot quicker if you just follow the rules and answer the question that's asked.
So you nor Mr. Mosley, I'll ask about yourself, have a closing letter that states that Mr. Mosley should have supervised visitation. How was Mr. Mosley supposed to know that he had supervised visitation if he did not receive a letter or anything to that effect from Texas Department of Family and Protective Services?
It was communicated to him.
Do you know that for a fact?
That's what I was told.
I'm not asking what you were told. Do you have personal knowledge that that was communicated to Mr. Mosley?
No.
In your affidavit, you also state that Mr. Ryan was evicted from his last residence. Is that right?
Yes.
Were you present at some eviction proceedings?
No.
Do you have a copy of the eviction proceedings?
No.
Okay. You also said that Mr. Mosley lives with, not Mr. Mosley, Jerry. Whom did you say lives with Mr. Mosley?
Jeremy Long.
Okay. Do you have a lease that shows that Jeremy Long lives in the home with Mr. Mosley?
No.
Have you been to the home and Mr. Long in the home with Mr. Mosley?
No.
Okay. So that's an assumption on your part?
Sure.
Okay. You also state in your affidavit, that there was an incident at a public swimming pool. Do you recall that in your affidavit?
At a public swimming pool.
On June 22nd, 2019, the police were called to a public swimming pool.
Oh, when she was at his house. Yes.
Okay. On that day, you said the police were called out. Is that right?
Yes.
Again, you say he was consuming alcohol. Was he arrested on that day?
Not that I know of.
Was he booked or charged with anything on that day?
I wasn't there.
Okay, so your affidavit speaks of something that you don't have personal knowledge to. You just said you were not there.
It was something my daughter communicated to me.
So you don't have personal knowledge, but you put it in the affidavit that you swore to. Is that correct?
I mean, I feel like if my daughter.
Yes or no?
Yes.
Okay. You also state that he constantly misses visitation. Isn't it true that you prefer to drop off and pick up the child? Is that right? You've been doing it for a while. Is that correct? Yes or no?
Yes.
Okay, thank you.
Prefer it.
Hold on, there were two questions there, and one was, do you prefer doing it that way? The other one is, you've been doing that for a long time.
I'd like to strike the first question. So
Okay.
my question would be, sorry, Your Honor. So my question would be, you've been doing that for a long time?
Yes.
Okay, your affidavit also states, let's see, on November 27th, 2018, He came to your daughter's school to have lunch with her for a birthday, was clearly high on prescription pain pills at the
It was not
time.
her school, it was her birthday party.
Okay, I'm reading from your affidavit, which is Exhibit C that has been offered into evidence,
Objection, that has not been offered into
which
evidence.
was attached as your supporting affidavit, Exhibit
Sustained
C.
that it wasn't been offered into evidence is sustained, but you may continue your question, Ms. Dent.
Okay, Your Honor, on November 28th, 27, 2018, you said he came to the school clearly high on prescription pills. Do you have a medical background?
Yes,
And what is your medical background?
I'm a licensed nurse.
And you are trained to know if someone is high on pills.
I worked for West Oaks Psychiatric Hospital, their
yes.
chemical dependency unit.
That my question is, you're trained to recognize specifically as a person is high on prescription pain pills.
Yes,
So you can tell whether it's pain pills as opposed to cocaine. You can tell that from looking at the person.
yes, actually.
Okay, your affidavit also says, well, you said Mr. Mosley refuses to give you information on where he currently lives, but you do go over to where he's currently living to drop off the child. Is that right?
I don't have the apartment number.
You currently go over to where he's living to drop off the child. Is that right?
To the front of the complex.
Okay, your affidavit also isn't it true that you also use drugs?
No,
You've never used any drugs in your life?
not that weren't prescribed to me.
Never used any ecstasy?
No,
Never used any marijuana?
not since high school.
Okay, my question was previously, have you ever used any drugs in your life? Your answer was no, so that was not true.
Objection, relevance, it predates the order.
Yeah, sustained. Let's just stick to since the order was rendered.
Have you ever used LSD in your life?
Objection,
Prior
time
to the
frame.
order,
Sustained.
have you ever used any type of Xanax after the order?
No,
What about volume after the order?
no,
You ever do any drugs with Amy?
no,
You ever do any drugs with Lee Holt?
no.
Is that a yes or a no?
No,
Do you make it a habit to go out of town to see your boyfriend in Alabama?
Objection, relevance.
It has definitely had to do with the child. It's definitely relevant.
Overruled. You may answer that.
I traveled out of town when I didn't have her. Yes.
And when you didn't have her, so where did she go?
At the time he was allowed visitation, then I would at times go out of town on those weekends.
Okay, so you've never gone out of town and left your daughter with Tim, ex-husband, I believe?
No.
She's never stayed over there,
Oh, she goes over there by choice sometimes. Yes.
but you've never gone out of town to see your boyfriend and left over there?
No.
All right, are you aware, or do you know whether or not she sleeps in a room where the dog feces are on the floor?
No.
I didn't hear your answer.
No.
Has she ever told you anything like that?
No.
Are you aware that when you leave your daughter home alone, she'll text her dad and tell him that she's scared?
Objection, assumes facts not in evidence.
I was asking her if she was aware, Your Honor.
She's allowed to ask leading questions, so overruled. I'll allow that.
No.
That's all I have, Your Honor. I'll pass this witness.
All right, Ms. Pierce, anything further?
I have a couple of follow-ups. Who called you to pick up Riley in March?
The Houston Police Department.
And who was with Mr. Mosley when you were called?
Jamie Espinoza,
And who is Jamie Espinoza?
another one of his friends that I guess he was staying with that weekend. They were in Kingwood at Jamie and Angelique's house.
Do you know Mr. Espinoza to use drugs?
Yes.
I have a question. If Mr. Mosley were intoxicated by something other than alcohol, would a breathalyzer pick it up?
No.
And how did you find out he was evicted?
He, at that time, he lived in the same townhomes that my mother lives, and she knows the owner of the townhome.
And how long ago was that he was evicted?
December, it's been a couple of years, December 2019.
And has he ever updated an address with you or the court since that time?
No.
You stated that you are a nurse,
Yes.
and where did you previously work?
In regards to my knowledge of chemical dependency,
Yes.
West Oak Psychiatric Hospital and the Chemical Dependency Unit, and also Center for Success and Independence, which is a dual diagnosis rehab facility for adolescents.
And have you had extensive experience with substance abuse disorders?
Yes.
Do you consider Mr. Mosley to have a substance abuse disorder?
Yes.
I'll pass this witness, Your Honor.
Ms. Dent, anything further?
Just real quickly, going back, she said she would go out of town, Your Honor. A couple of questions. When you would go out of town, or rather, since Texas Department of Family and Protective Services had been involved, was there occasion that Mr. Mosley tried to get possession of the child?
No.
One second, Your Honor.
Sure.
Okay, Ms. Mosley, on May 7th, Mr. Mosley didn't attempt to pick up the child
No.
from your home?
No.
How about May 21st?
No.
The Fort Bend Police Department didn't come to your home on May 21st?
They came for a welfare check.
Okay, they didn't inform you that Mr. Mosley was there to pick up the child for the scheduled visitation, and you said you would not?
No, ma'am.
No knowledge of that?
No, ma'am.
How about June 4th?
No, ma'am.
Did the officers from Fort Bend County Police Department come to your home on that day?
And state that they were doing a welfare check.
And they never told you that Mr. Mosley was there to pick up the child for the scheduled
No, ma'am.
visitation? And how about on June 18th?
No, ma'am.
Fort Bend County Police Department did come out to the home?
And again stated they were doing a welfare check.
Right, but they never told you that Mr. Mosley was there to pick up the child for a scheduled visitation?
No, ma'am.
How about July 1st?
No, ma'am.
Did Fort Bend County Police Department also come out on that day also?
No, ma'am, they didn't. July 1st was a Thursday. They came out July 2nd, that Friday, and stated they were doing a welfare check.
Right, and at that time, did they tell you that Mr. Mosley was there for a scheduled visitation?
No, ma'am.
So you had no knowledge when the police officers came that Mr. Mosley was trying to get his scheduled visitation?
No, ma'am. They always stated it was a welfare check.
You also stated on previously that you had the Texas Department of Family and Protective Services, you didn't have a letter, but that the case was closed. Did Mr. Mosley ever text you a copy of the letter that he received from the Texas Department of Family and Protective Services?
Yes, ma'am.
And didn't he in fact text you the letter that said it was closed with no further action on more than one occasion?
Just once, but he did send it to me.
Right. So you had knowledge that Mr. Mosley had in his hand. Do you strike that, Your Honor? Whose name was on that letter, if you recall, that he texted to you? From the Texas Department of Family and Protective Services, the letter that Mr. Mosley texts to you, the closing letter, do you recall whose name from the Texas Department of Family and Protective Services was on that letter?
I don't.
Would it surprise you that it was Matthew First?
I mean, he was the investigator, so no, it wouldn't surprise me.
Okay, so it wouldn't surprise you that Mr. Mosley received a letter from Matthew First that said the case was closed with no further action. It wouldn't surprise you.
No, ma'am.
Objection, Your Honor.
No further questions, Your Honor.
Ms. Pierce, any redirect?
I have just a couple of questions. Ms. Dent asked you numerous dates if Mr. Mosley appeared at your door to demand you surrender the child. Do you remember that? Do you remember
Her line of
question?
question. Yes, ma'am.
Okay. On any of those dates listed, did he ever come to your home and knock on your door?
No, ma'am.
Are you ordered to release your child to a police officer?
No, ma'am.
Um, I'll pass the witness, Your Honor.
Ms. Dent, anything further from this?
I have no
witness?
further questions, Your Honor, for this witness.
All right, Ms. Pierce, you may call your next witness.
I'd like to call Ryan Mosley.
All right, Mr. Mosley, you're being called as an adverse witness. What that means is Ms. Pierce is going to be allowed to ask you leading questions that may be suggestive and may call for a yes or no response or a short response. I want you to listen carefully to those questions and just answer the question that's asked, because your lawyer is going to get an opportunity to ask you questions as soon as she's done. And if she feels like you need to explain one of your answers, she's going to give you an opportunity to do that. All right, Ms. Pierce, you may proceed.
Thank you. Can you state your name for the court?
Jerry Ryan Mosley,
And where do you live?
5007 FM 1960 Road West, Houston, Texas 77069,
Yeah. What's your apartment number?
233.
How long have you lived there?
For over a year. Well, right under a year.
Who lives with you?
Nobody.
Do you have a lease?
Yes, ma'am.
And you're the only person on that lease?
Yes, ma'am. In fact, I think it's an exhibit.
I don't have it. So, who is Jeremy Long?
Jeremy Long is the brother of Josh Long, who Casey Mosley was having an affair with.
Objection.
Overruled.
He's not your friend?
No, ma'am. He's an acquaintance of my brother.
Do you ever hang out with him?
I have in the past. Yes, ma'am.
Would it
We all
surprise
have in the past, to be honest.
Would it surprise you that his driver's license lists your address, apartment 233, as his legal address?
Yes, ma'am. It would surprise me. I can't
Um,
stop somebody from having mail sent to my house.
Are you employed?
Yes, ma'am.
How long have you been employed?
For 3 months now.
Who are you employed with?
Planet Fitness
And where were you employed before that?
at the Comedy Lounge.
Doing what?
Bar manager.
How much do you make at Planet Fitness?
$17 an hour.
And how much is your lease? How much is your monthly rent?
I'm going to object, Your Honor, as to relevance. I don't believe we have any pleadings on file as to any type of modification of child support.
Yeah, we're just here on the possession and access for purposes of this temporary order hearing, so the objection sustained.
Okay. Prior to living, when you moved into that, when you got that lease, did you notify the court of your change of address?
No, ma'am. Casey Mosley was very, very well aware of it. She used to drop my daughter off, and she saw us enter my house, my apartment, several times.
Where did you live prior to that?
At 14323 Still Meadow.
And did you live with anybody there?
No, ma'am.
How long did you live at Still Meadow?
For over a year.
Where does Riley sleep at your apartment?
In her bed.
Is it a 2-bedroom apartment?
No, ma'am. It's 1 bedroom. I've got a hideaway bed.
And where does her hideaway bed go?
Goes underneath my bed, and whenever she's here, I put it right next to mine.
Do you have a valid Texas driver's license?
Actually, not yet. I'm waiting for it to come back. It was just recently reinstated.
What county were you in when you got a DWI or DUI?
Objection, Your Honor. Assumes fact not in evidence.
I don't have a DWI.
Be quiet, Mr. Mosley.
Overruled. You may answer that, sir. You said you don't have a DWI?
No, sir.
Do you have a DUI?
Yes, ma'am. From about 7 or 8 years ago.
And what county was that in?
Harris County.
How many DUIs have you been arrested for?
1.
That's the only one?
Yes, ma'am.
So if we find one from a couple of years ago, there's.
Objection, Your Honor. Asked and answered.
Sustained.
Why was your license suspended?
Because I had some traffic violations.
It didn't have anything to do with the DUI?
No, ma'am.
Do you have to have an SR 22?
No, ma'am.
Have you used any illegal drugs in the last 90 days?
No, ma'am.
How do you explain such a high level of marijuana?
I went to Colorado the last part of April. I suffer from PTSD.
So is it, well, that's actually, I'll pass this witness.
Ms. Dent?
Thank you, Your Honor. Let's go to the incident in the park, Mr. Mosley. Can you explain to the court what happened on that day?
Yes, ma'am. I was chasing Riley. We were running around chasing each other, playing tag. She ran up the little jungle gym, and she approached a slide that has a iron bar right above it, and below it is the slide. She was running. She grabbed onto it with her arms and swung her body underneath it and went down the slide. I followed in suit, thinking I could do the same thing. However, I guess I've grown a little bit, and my arms are a little bit longer. Whenever I swung, I hit the back of my head on the top of the slide, and it knocked me out.
Okay, at any time prior to going to the park, had you had any type of illegal substance on that day?
No, ma'am.
When you hit your head, did you become unconscious?
Yes, ma'am.
Was an ambulance called?
Yes, ma'am.
Did the ambulance arrive to the scene?
Yes, ma'am.
Did the police also arrive to the scene at the park?
Yes, ma'am.
At that time, I guess when you came through, did you really know what was going on?
Not at all.
Objection leading.
Sustained.
Did you know what was going on?
No, ma'am.
Did the paramedics check you out?
Yes, ma'am.
At the time in the park, did you submit to a breathalyzer?
Yes, ma'am.
Did it come back showing that you had any alcohol in your system?
No, ma'am. Not at all.
Was blood also drawn?
Yes, ma'am.
At some point, did Child Protective Services get involved?
Yes, ma'am.
Tell me where the park was located.
The park was located in Northwest Houston and Northwest Harris County in Kingwood, Texas.
Okay, the CPS worker came from where?
The CPS
What
worker
county?
came from Fort Bend County down in Southwest Houston.
Okay. Was an employee from the Child Protective Services dispatched to your home at some point after this incident?
Yes, ma'am.
And was that person Christina Hall and another individual?
Yes, ma'am.
Do you recall the other individual's name?
No, ma'am. I sure don't.
Did they come into your home?
Yes, ma'am.
Did they speak to you in your home?
Yes, ma'am.
Did they look around your home?
Yes, ma'am.
They do an assessment to your knowledge?
Your Honor, all of these questions have yes or no answers, and I object because they're leading.
Well, just make your objection when you're making it. Objection is sustained to leading.
Was an assessment done in your case?
No, ma'am.
Who was the caseworker that was assigned to your case?
Matthew First.
And did Mr. First, when did Mr. First initially contact you?
He never did.
At any time?
No, ma'am.
What was your first encounter with Mr. First?
I contacted him.
Okay. Were you given a safety plan?
No, ma'am. I have no idea what that is.
Okay, so did you get something telling you what you could and could not do during the investigation?
No, ma'am, not at all. The only kind of letter I received from CPS was a closing letter.
Did Mr. First, you heard Mr. First testify earlier, did he request that you contact the Cradles Project?
Yes, ma'am.
Did you contact them?
Yes, ma'am.
Were you able to use their services?
No, ma'am.
And do you know why not?
Yes, ma'am. Due to the fact that they were waiting on some forms from Mr. First that never got sent.
Okay. Did they need those forms for you to proceed with you now?
Yes, ma'am, I sure did. They also stated that these were
Hold
very
on,
common
hold
forms.
on. Let me ask you the question. Did Mr. First at any time come to your home?
No, ma'am.
Did he do an assessment asking you questions during the investigation?
No, ma'am.
Ms. Mosley stated on her direct that she received a safety plan. Well, she said she did not receive a safety plan that said that you were to have supervised visitation. Did you receive any type of safety plan or letter that said you were to have supervised visits with your daughter?
No, ma'am.
Did you provide Mr. First with names for supervisors?
Yes, ma'am.
Approximately how many names did you provide to Mr. First?
5 of them.
Were they all declined or no?
Yes, ma'am, they were all declined.
Do you believe that you did everything that Mr. First asked you to do?
Yes, ma'am, 100%.
Do you believe that did Mr. First follow through on all that he needed you to do?
No, ma'am, not at all.
Mr. First testified that you called him, you were upset. Can you explain to the court why you were upset when you contacted Mr. First?
Because he hadn't sent the forms. I was trying to get everything taken care of so I could get so I could see Riley. And the fact that he was having relations with my ex-wife.
Okay, and did you receive documentation from the Texas Department of Family and Protective Services?
Say that again?
Excuse me. Did you receive any type of documentation from the Texas Department of Family and Protective Services?
Yes, ma'am, I sure did.
And was it a closing letter letting you know what was going on?
Yes, ma'am, said the case was closed.
Okay, we have submitted what has been pre-marked as Exhibit 1. Can you take a look at it?
Yes, ma'am, bear with me 1 second.
Do you have it?
Yes, ma'am.
Okay, do you recognize it?
Yes, ma'am.
What do you recognize it to be?
The closing letter.
Did you receive this letter on about May 3rd of 2021?
Yes, ma'am, I sure did.
Is it in the same form as which you received it?
Yes, ma'am.
Has there been any changes or alterations to that document?
No, ma'am, not at all.
Your Honor, I would like to offer what has been pre-marked as Exhibit 1 into evidence.
Any objection to R1?
Yes, it's hearsay.
All right, our objections overruled. R1's admitted.
Okay, Mr. Mosley, the Exhibit 1 that you have,
Yes, ma'am.
Can you read to the court what it says?
Sure. It says the family from the Department of Family and Protective Services had received a report concerning the safety of children in your family. Upon receiving the report, we referred Family Alternative Response Program. The Department of Family and Protective Services met with your family and completed a safety assessment. Because there's no current concerns related to the safety of the children in your home, your case will be closed with no further action.
Okay, and whose name is at the bottom of that letter?
Mr. Matthew First.
Okay, is that the same Matthew First that is the investigator on your case?
Yes, ma'am.
Did you interpret this letter to mean that you had supervised visits with your daughter?
No, ma'am, not at all.
Did you interpret this letter to mean that Ms. Mosley should keep your child away from you?
No, ma'am.
Okay. This letter, did you at any time present it to Ms. Mosley?
Yes, ma'am, 2 different times.
And how did you do that? What form?
I sent it to her in
Let me finish my question first. How did you present that to Ms. Mosley?
a text message.
Okay. After you presented that to Ms. Mosley, did you attempt to get possession of your child for your visitation?
Yes, ma'am.
On May 7th, did you attempt to pick up the child from Ms. Mosley's resident at 17215 Dogwood Trail, Richmond, Texas?
Yes, ma'am.
And you were there to pick up the scheduled visitation for 6 o'clock?
Yes, ma'am.
Did you do anything prior to going? Or on your way there?
Yes, ma'am. I contacted the Fort Bend County Sheriff.
And why did you do that?
Because I didn't have her exact address. She doesn't have her address on file, and they asked me to not to approach the door.
Okay.
That they would actually go up there.
And did they come out and assist you?
Yes, ma'am.
On May 7th of 2021, did you get possession of your child for your scheduled visitation?
No, ma'am.
Did you try again on May 21st?
Yes, ma'am.
And I'm sorry, going back on May 7th, 2021, did anyone accompany you to the home?
Yes, ma'am. Tony Mondragon.
Okay. On May 21st, did you try again to get possession of your daughter?
Yes, ma'am.
And did you arrive at the home at 17215 Dogwood Trail, Richmond, Texas, 77407?
I did not. I was asked not to go to the home.
Now listen to my question. On May 21st, 2021, I'm not asking if you got out at the home. Did you arrive at the home at 17215 Dogwood Trail, Richmond, Texas?
Yes, ma'am. Yes, ma'am.
And were you there to get your scheduled visitation at 6 o'clock p.m.?
Yes, ma'am.
Did you call any police department at that time?
Yes, ma'am.
Whom did you call?
The Fort Bend County Sheriff's.
And did the Fort Bend County Sheriff's Department come out to assist you?
Yes, ma'am.
When the officer showed up, do you know if the officer went to the door?
Yes, ma'am.
And at that time you were at the residence?
Yes, ma'am.
And did you find out that the child would not be turned over to you for your scheduled visitation?
Yes, ma'am.
At 6 o'clock p.m.?
Yes, ma'am.
On that day, did you receive an incident report from the Fort Bend County Police Department?
Yes, ma'am.
And it was at number P211-40785?
I object to council reading from a document not admitted into evidence.
Overruled.
These are my notes. Did you also receive an incident report from the Harris County Sheriff's Department?
Yes, ma'am.
And was it incident number 210-508489?
Yes, ma'am.
So you were denied visitation on that day?
Yes, ma'am.
And the days that I'm asking you about are these days after you had forwarded the letter you received from the Texas Department of Protective Services to Ms. Mosley via text on 2 occasions?
Yes, ma'am.
Okay, on June 4th, 2021, did you also attempt to pick up your daughter from the home located at 17215 Dogwood Trail?
Yes, ma'am.
And was it for your 6 o'clock visit?
Yes, ma'am.
Did you arrive at the home? Not asking if you went in, did you arrive at the home?
Yes, ma'am.
Did you contact anyone for assistance?
Yes, ma'am.
Who did you contact?
Fort Bend
Whom?
County Sheriff.
Okay, and did they come out?
Yes, ma'am.
When they were dispatched to the home, did they knock on the door?
Yes, ma'am.
Did anyone answer the door at that time?
No, ma'am.
So the respondent was not there?
Yes, ma'am.
Objection assumes facts not in evidence.
No one answered,
Overruled.
no one answered the door?
No, ma'am.
Okay, did you receive your child for the scheduled visitation on that day?
No, ma'am.
Did you receive a incident report from the Fort Bend County Police Department?
Yes, ma'am. I sure did.
Was it P211550898?
Yes, ma'am.
You also attempt to pick up your child one more time on June 18, 2021
Yes, ma'am.
from the home located at 17215 Dogwood Trail, Richmond, Texas.
Yes, ma'am.
And this was for your 6:00 p.m. visit.
Yes, ma'am.
And it was also after you received the closing letter from the Texas Department of Family and Protective Services and sent it over to Ms. Mosley.
Yes, ma'am.
Did you contact anyone for assistance?
Fort Bend County Sheriff's.
Was an officer dispatched to the home?
Yes, ma'am.
Do you know if the officer knocked on the door?
Yes, ma'am.
And you were waiting at the home?
Yes, ma'am.
Were you instructed to stay in the car or to get out the car?
I was instructed to stay in the car.
Okay, and did the officer knock on the door?
Yes, ma'am.
Were you informed that the child would not be released to you at that time?
Yes, ma'am.
For your scheduled visitation?
Yes, ma'am.
So the child was not released to you on that day at 6:00 p.m. for your visitation?
No, ma'am.
And did you receive an incident report from the Fort Bend County Police Department?
Yes, ma'am.
And was that number P211690931?
Yes, ma'am.
Okay, and I didn't ask you, the last visit that you went, did someone accompany you to those visits to the home?
Yes, ma'am. All visits were accompanied with me by Tony Montagon.
Okay, thank you. On July 1st or July 2nd, 2021, did you attempt to pick up your daughter for the summer visitation from the home
Yes.
located at 17215 Dogwood Trail, Richmond, Texas?
Yes, ma'am.
And did you attempt to pick your daughter up for that 6:00 visitation?
Yes, ma'am.
And you arrived at the home.
Yes, ma'am.
Did you contact anyone at that time?
Yes, ma'am.
And whom did you contact?
Fort Bend County Sheriff.
And was an officer dispatched to the home?
Yes, ma'am.
Were you instructed to get in the car or stay in the vehicle, or get out the vehicle?
Stay in the vehicle.
Objection calls for hearsay.
Sustained.
When the officer dispatched, did he knock on the door?
Yes, ma'am.
Were you informed that the child would not be released to you for the scheduled visitation?
Yes, ma'am.
Was the child released to you for your 6:00 p.m. visitation?
No, ma'am.
And that was for, you arrived for your summer visitation?
Yes, ma'am.
At any time during the summer of 2021, did you have possession of your child?
No, ma'am.
Did you get a incident report from the Fort Bend County Police Department?
Yes, ma'am.
And was that P211830901?
Yes, ma'am.
And did anyone accompany you on that visitation?
Yes, ma'am.
And
Tony
who was that?
Montagon. Tony
Okay.
Montagon.
Have you ever showed up to your daughter's school high on any type of drugs?
No, ma'am.
Have you ever showed up to your daughter's birthday parties high on any type of drugs to pick her up for visitation?
No, ma'am.
In the petitioner's affidavit, she alleges in one incident occurred at a public pool in 2019. Are you aware of that in the affidavit?
Yes, ma'am.
And that incident that the petitioner speaks about, were you arrested on that day?
No, ma'am.
Were you charged with any crime on that day?
No, ma'am.
Were you evicted from your home?
No, ma'am.
Any eviction proceedings that went on?
No, ma'am.
Ever went to court and the judge issued an eviction for you?
No, ma'am.
Does the petitioner use drugs?
Yes, ma'am.
Have you ever seen the petitioner use drugs with your own eyes?
Yes, ma'am. Several times.
Have you ever seen the petitioner use marijuana?
Yes, ma'am.
Have you ever seen the petitioner use ecstasy?
Yes, ma'am.
Objection, time frame.
Sustained.
Are you aware whether or not the petitioner pops pills?
Yes, ma'am.
Objection, time frame.
It's already answered, but.
Okay.
I'm really only concerned about what's happened since the last order. Extent.
Okay, since the last order, are you aware of the petitioner drinking any type of alcohol beverages?
Yes, ma'am.
Are you aware of the petitioner getting drunk
Yes, ma'am.
after the last order?
Yes, ma'am.
Okay. Do you have any type of medical diagnosis?
Yes, ma'am.
Okay, I want you to look at what has been pre-marked as Exhibit 4. Do you have it in front of you?
Bear with me 1 second.
It's the one that says King Haven Counseling. If you look at the bottom left, it has the number on it.
Yes, ma'am.
Do you see it?
Yes, ma'am.
You have Exhibit 4?
Yes, ma'am. I just lost it. Hold on.
Let's see.
Do you have it?
Yes, ma'am. I've got it now.
Okay. The one that says King Haven at the top?
Yes, ma'am. Bear with me 1 second. It's loading up.
Okay.
Okay, you can go ahead.
Okay, so you see what has been pre-marked as Exhibit 4. Do you recognize it?
Yes, ma'am.
Okay, let me go back. Do you have any type of medical diagnosis?
Yes, ma'am.
And what is your medical diagnosis?
Objection to the council reading from a document that's not been admitted into evidence.
I'm not reading. I
heard the object. I mean, I heard the question. You're just asking if he has a diagnosis. The objection's overruled.
Do you have any type of medical diagnosis?
Yes, ma'am.
And what is your medical diagnosis?
PTSD, post-traumatic stress disorder.
Okay. Did you receive this diagnosis from the King Haven and Dr. I don't want to mess up the name, Aziz?
Yes,
Objection to the, objection to council reading from a document not admitted into evidence.
Sustain.
Did you get this diagnosis from a doctor?
Yes, ma'am.
Was that doctor located at the King Haven Counseling Group?
Yes, ma'am.
Okay, looking at Exhibit 4. You still have it?
That's the King Haven.
Yes. Do you recognize it?
Yes, ma'am, I do.
What do you recognize it to be?
My diagnosis from King Haven.
Okay. And is it in the same form as it was when you received it?
Yes, ma'am.
And what date did you receive this?
September 6th.
Could we clarify a year?
Oh, 2021.
The full date you received it?
September the 6th, 2021.
And is this letter that you received in the same form as it was when you received it?
Yes, ma'am.
Has it been altered or changed in any manner?
No, ma'am.
I would like to offer Exhibit 4 into evidence, Your Honor.
Here's
Yeah, I object hearsay, and it's
Sustained.
prepared for court.
Objection sustained. R4 is not admitted.
How long have you been diagnosed with PTSD?
Over 7 years.
Okay, but you have seen a doctor for that,
Yes, ma'am.
and you have gotten a diagnosis.
Yes, ma'am.
Okay, can you look at what has been pre-marked as plaintiff as Movers Exhibit 8?
From Floweret?
Yes.
Yes, ma'am.
Have you been seen by a doctor at Floweret, MD?
Yes, ma'am.
Are you currently in the compassionate use program?
Yes, ma'am.
Objection leading.
Sustained.
Are you currently in any programs?
Yes, ma'am.
And what program would that be?
Texas Compassionate Care Act.
Okay, were you prescribed, what were you prescribed for your PTSD?
THC cannabis.
And high grade or low grade?
A low grade.
Okay, if you look at Exhibit 8, do you recognize it?
Yes, ma'am.
What do you recognize it to be?
My letter of approval for the Texas Compassionate Care Act.
Is it in the same form as when you received it?
Yes, ma'am.
Any changes or
No.
modifications to it?
No, ma'am, no.
And is it in substantially the same form?
Yes, ma'am.
I would like to offer Exhibit 8 into evidence.
I object improper predicate unless I don't remember hearing a date. And it's also hearsay.
All right,
Can
Ms.
get the
Dent,
date.
hold on, Ms. Dent, Ms. Dent, can you give us the date? I didn't hear the date either. For
Uh,
the-
Mr. Mosley, on what date was this prescription given to you?
September the 18th of 2021.
Is that date indicated on the prescription that you have from Floret MD?
Yes, ma'am. Yes, ma'am. It's in the top right-hand corner.
I would like to renew my motion to have Exhibit 8 offered into evidence.
All right,
I'm objecting, it is hearsay.
all right, response, Ms. Dent?
It's not offered for the truth of the matter therein, Your Honor, just that he has one.
I believe it's to bolster his testimony, Your Honor, and so I still object that it's hearsay and it's prepared for court.
It is,
The court agrees it's hearsay, but I'm gonna admit it for the limited purpose that he has been prescribed something on September the 18th of 2021. So the objection's overruled. R8 is admitted for that limited purpose.
thank you, Your Honor. Did there come a time that we know that there's a drug test?
Yes, ma'am.
And the drug test came back positive.
Yes, ma'am.
And from your recollection, in the last 6 months, was there a time that you had some cannabis in your system?
Yes, ma'am.
Can you explain to the court when and where that was?
Yes, ma'am. It was in Colorado, right at the end of April. I had gone to Colorado. My PTSD was flaring up. So I went to Colorado and partook in marijuana.
Okay, have you done that since you've been back in Texas?
No, ma'am. It's illegal.
What was the purpose of you getting the prescription for the cannabis?
Because I live in Texas.
What was your reasoning for doing it?
Because I suffer from PTSD.
Okay, and your doctor prescribed this for you?
Yes, ma'am.
Okay. Can I have one moment, Your Honor?
You may, and I'm just gonna let both lawyers know, was told I've got a trial at 1:30 this afternoon, so if we don't finish in the next 7 minutes or so, y'all are looking at coming back, just so you know.
Okay, I passed the witness, Your Honor.
All right, Ms. Pierce, your witness.
I have a few questions. Did you go to the hospital to be seen after the park incident?
No, ma'am.
Okay, so you were not completely unconscious and didn't even go to the hospital to see if you had a concussion or anything?
No, ma'am. Ambulance came to me.
Which hospital has your medical records relating to this blood draw you spoke of? And
I'm not sure.
why would Mr. First ask you to contact the Cradle Project? What is the Cradle Project?
I have no idea.
You contacted him, didn't you?
Yes, ma'am.
You didn't ask him, what are y'all?
No, ma'am. I asked him what I needed to do to get the ball rolling.
How did you send police to her address when you just testified you didn't know where she was living?
Because one time Casey sent me a picture of Riley's report card, and it had her address on there. And seeing as though I hadn't seen my daughter and she was keeping her from me, I suggested to have the police go to her house.
So you actually knew her address.
Yes, ma'am. I ended up finding it out because I needed to. I needed to find out where my daughter was.
When were you first diagnosed with PTSD?
About 7 years ago.
And who diagnosed you?
My psychologist.
What was his name?
I don't know. I have to look in my records.
I also noticed on, may I share the screen briefly, Your Honor?
No.
on Exhibit 8, that Dr. Jacqueline Rice McKenzie, when did you first meet her?
Back in August
Of what year?
2021.
And you testified earlier that you hadn't used any THC since April, but you're saying to the court you were prescribed THC September 18th. Is that correct?
Yes, ma'am.
I'd like to offer, it's called R1 from my documents. It's a government document under seal, Your Honor.
Response, Ms. Dent?
I'm looking to see which one is R1, Your Honor.
We're gonna have to relabel it too, 'cause we've already got respondents exhibits for Ms. Dent,
Oh,
but we can do that. We can do that. I understand it was on your, it sounds like on the motion for enforcement, but Ms. Dent, what, do you have R1 in front of you that you can review?
Is it the detailed history?
Yes.
Yes. Okay,
Yes.
I do have it, Your Honor.
Do you have any objection to that exhibit?
I do not.
All right, let's, for purposes of the record, I know it's labeled as R1 probably in the court's email, but we're gonna make that petitioner's. Do you have any other exhibits? Can I make that petitioner's 10, Ms. Pierce? Is that far enough out?
Oh, I don't have any, that's it, Your Honor, I think. I mean, whatever, I'm trying to figure out what's my, this would be 3.
All right, we're gonna make it petitioner's 10, just to be safe. That way I can just add a 0 and change the R to a P.
Okay.
The petitioner's 10 is admitted.
May I share?
You may.
Okay. Mr. Mosley, I'd like you to look at what's been identified as petitioner's 10 and ask you, is this a detailed history of police events?
That's what it looks like.
Okay. Want to go down here to, this says it was created on May 21st, 2021. Do you see that?
Yes, ma'am.
If I go down to here, it says, spoke to the mother, Casey, observed Riley to be in good health. Mother was concerned, and this was the 3rd we have been to the address in 2 days. Casey stated daughter attempted to contact reportee twice, but he doesn't answer the phone. Casey stated reportee's visitation rights have been taken away due to drug test he recently failed. Do you see this part right here?
Yes, ma'am.
Right. So did they give you a call at that point?
Yes, ma'am.
Now I want to go down to 6-4. Do you see 6-4?
Yes, ma'am.
Do you know what time 1833 is?
6:33.
Okay. So at 6:33, the police officer records that you are calling from Houston. Is that correct?
Yes, ma'am. That's where I live.
Right. Well, how could you have been at her door with the police or sitting in your car out in front of her house if you were calling from Houston?
They told me to call them right down the street whenever I was 5 minutes away.
On this date, 6/18, it states, RP advised he has a custody agreement with his exit wife to get his daughter. He advises he lives about 45 minutes away from above address. Do you see that?
Yes, ma'am.
Can you tell me what time the police officer entered this? Right here.
1818.
That would be 6:18, is that correct?
Yes, ma'am.
And at that moment, you were still 45 minutes away?
No, ma'am. Once again, you've got to understand, I've done this several times, so I know how this process goes. I called them when I was 5 minutes away.
Okay, at 6:30, the officer says, spoke with RP who was not on scene for court-appointed time to get child. Do you see that?
Yes, ma'am.
On 7/2,
I was told not to go to the scene. I was told to wait up the street.
at 5:51, it says RP will be waiting at the parking lot of the Science and Technology Building. Is that where she lives,
Who?
your child?
Is that what you mean? No,
Does she
ma'am.
live at the Science and Technology Building?
No, ma'am. But that's where the police officer
Objection.
instructed me to go.
He's staying.
Both of these documents, one that was admitted 8 and the other one that was not admitted, exhibit R4, they were both prepared in September of 2021. Is that correct?
Yes, ma'am.
I'll pass this witness.
Ms. Dent, anything further from this witness?
Really quick, as to the dates that Attorney Pierce just asked you about, of all those dates, were any of those dates you testified to on direct from me, except for June 18th?
Say that again.
The dates that Ms. Pierce just went through on the document at petitioner's 10 that you were
Oh,
just
okay.
looking at?
Yes, ma'am.
Okay, she called out several dates to you.
Yes, ma'am.
Of all those dates, were those any of the dates that you testified to when I was asking you questions besides June 18th?
No, ma'am.
That's all I have, Your Honor.
Pierce, anything further?
No, Your Honor. I would like to ask that my request for fees be reserved for time of trial.
All right, I'm going to give each lawyer just like a minute to give me brief closing arguments. Ms. Pierce, you're the representing the movement, so you may proceed.
Your Honor, my client is concerned about the safety of her child. She's not trying to keep Dad from having access to the child. However, she wants it to be in a safe situation, and she wants it to be without stress on the child. And so, Your Honor, we've requested whether it be that she even have to meet at a restaurant in public, or whether it be at the Harris County DRO, or a private supervisor, or the people that she recommended to the court that she approved. We're asking that until we can assure that the child is safe, due to the high levels that Mr. Jeffries testified to, that's a chronic daily user who's testified in court that he hasn't used since April. And so we're very concerned, Your Honor, about the veracity of that. And we're asking that the court just put some orders in place until we can make sure that Riley is safe in her visits with her dad. And additionally, we're requesting that if the court orders supervised, that Dad be required to pay the supervisor fees for the actual visits.
You're breaking up. I can't hear you.
Is it happening again, Judge?
No, I heard you. She's asking, the last statement was, she's asking that if there is a agency that does supervising, that father be ordered to pay the costs associated with that. You may continue, Ms. Pierce.
And we're also requesting, Your Honor, that if the court's going to allow telephone access, that I guess the parties be admonished that it's a specific time and a specific duration. So, and I don't know whether, Your Honor, he actually contacts the child's phone. I don't know whether he ought to have to contact mom's phone. That way she has better control over what times of day that this is going on. So
are you
Your
telling
Honor,
me
we're
I
just-
should,
we're just-
are you
and we're
telling me I
asking
shouldn't answer my
Hold on,
daughter's
Mr.
phone calls?
Mr. Mosley, be quiet, please. Hold on, Mr. Mosley. Put your thank you.
Ms. Pierce, you may continue.
Oh, now I've lost my train of thought. So, Your Honor, we just want some safety in place for this child. Oh, it said it was unstable, but we want some safety in place for this child, and while the court's figuring out what's the best way to proceed.
All right, thank you, Ms. Pierce. Ms. Dent, closing?
Yes, Your Honor. Mom has no letter from the Texas Department of Family and Protective Services stating that there should be supervised visits or that mom should be protective of the child. The letter from Texas Department of Family and Protective Services that is signed by Matthew First, who is the investigator on the case, states that the case was closed with no further action. It does not stipulate to him, Mr. Mosley, having supervised visitation. It does not stipulate to Ms. Mosley being protective of the child and not letting the respondent see the child. Respondent has no way of knowing anything as to any type of supervised visits or anything ordering him, but for the letter that he received. In Exhibit 10, Petitioner's Exhibit 10 that counsel just presented, she read out loud that the petitioner stated to the officer that his visitation rights had been taken away because of drug testing. But in my cross, petitioner stated that that the officer didn't tell her anything about Mr. Mosley being there for supervised visits. The child has been safe. There was no testimony of any kind as to any injuries of the child while the child was in dad's possession. There was no testimony as the child being hurt while in dad's possession. We're asking that there be no supervised visitation, that dad continue to have the standard visitation. We also ask that he be given makeup visits for all the times that he missed after the Texas Department of Family and Protective Services rendered their closing document that said that the case was closed. Ms. Mosley certainly received a copy of it. I don't know if she received it from the Texas Department of Family and Protective Services, but usually they send it out to both parties. But Mr. Mosley did present it to Ms. Mosley on 2 different occasions. So she certainly knew after the dates testified to that that the case was closed and Mr. Mosley did have rights to visit with the child, but she chose to withhold the child from Mr. Mosley. That's all I have, Your Honor.
Thank
Your
you,
Honor,
Ms.
may I just briefly respond to the makeup time, because I was trying to say that when he's talked and I lost it.
No, ma'am.
just didn't believe there was-
I've heard all the argument I need to hear.
Thank
The
you.
entry of this order is going to be October 15th at 9 a.m. Ms. Pierce, you'll draft the order. I want to thank both lawyers for presenting a well-presented case. The court has some concerns. I've got a lab result that shows that I've got a chronic user, and those lab results predate any medication being prescribed for cannabis use. So I understand it happened in Colorado. I understand the PTSD diagnosis was 7 years ago. But the problem is I've got enough there that makes me suspicious as a court, that makes me want to err on the side of caution and make sure that we're on the right track now. And I'm not convinced right as I sit here right now that we're there. So Dad, I want you to do a few things. And my hope is we get a final trial date here in about 2 or 3 months from now, and that we're back to a standard possession order at that time. But I want a period of brief supervision to make sure that this is not a situation where someone was passed out from drugs. I understand that your explanation at the park, and I don't have any reason necessarily to doubt that, but there's enough there that I'm concerned. So I want to have about a 3-month time period to make sure everything's on the up and up. And if it is, this court will move you back to a standard possession order, because I believe that's in the child's best interest. If you're providing her a safe environment. The court's ruling is as follows. The request for temporary orders is granted. Father's access is modified. Possession and access is modified as follows. It will be on the Saturdays and Sundays following the first, third, and fifth Fridays of each month. The visitation is going to begin at noon and it's going to end at 4 p.m. Additionally, if dad wants it during the school year, he can have visitation on the Thursdays from 6 to 8 p.m. Also, because we're going to probably be hitting holidays before this turns into a final order, I'm going to give dad November 25th from noon until 6 p.m. Those periods of possession that the court just laid out are going to be supervised by one of the following: either Lee Holt, Amy Frazier, Mr. Mosley's brother, or Guardians of Hope if you can't get one of those individuals to do the supervising. If it's Guardians of Hope, there's a charge associated with that, and dad will be required to pay the charge associated with the supervised visits. Obviously, I want some visitation to take place, Mr. Mosley. To just wait 3 months, if there's no visitation, you're going to be in a period where you're looking at additional supervised visits. So exercise this. I know you don't agree with the supervisors. But that's the only supervisors I heard about today. So I know you had proposed some. I didn't hear about those today. So I'm going with the evidence that was presented to me. So hopefully you can get one of those 3 people to agree. If not, it'll be through Guardians of Hope. I'm also I gave dad every day of telephone access or FaceTime access because he wasn't getting any visitation. I'm going to modify that telephone access, FaceTime access, so that it's Mondays and Wednesday evenings. So it'll be 2 nights a week rather than every night. That being said, Mom, there is nothing that prevents dad from calling and talking to his daughter outside of these hours. He can call her and he can talk to her if she's available. I'm just having you court ordered and responsible to make sure she's available during those periods of time on Monday and Wednesday nights. Dad, don't call an 8-year-old at 10:15 at night. And I'm not saying, I don't know if you did that or not, but I heard testimony that you did. And that's not a good time. You shouldn't be calling after like 8:30 at the latest. She's an 8-year-old. She needs her sleep. And she hasn't seen you in a while,
Yeah.
it sounds like.
So am I not supposed to answer the phone when she calls me?
Hold on, Mr. Mosley.
If she calls you, absolutely you can answer the phone. I just don't want you initiating a phone call at bedtime hour. So anytime after like 8:30. But absolutely, if your daughter calls you, you can answer the phone. The other thing I was going to say is, I just lost my train of thought.
Can I have the brother's name so I can put it in?
Yes, please. I need it too. What's the brother's name?
Robert Sean Mosley.
All right, Robert Mosley. But Dad, you're going to get FaceTime access those 2 evenings. But you can call other times and talk to your daughter anytime you want. Just don't do it during sleep hours.
What are the times on Monday and Wednesday, Your Honor?
It's in my prior order,
Okay.
the times. I think it was between 6 and 7, but I want it to be consistent with what they were previously doing. Do y'all recall the exact time, Mr.
I
Mosley?
was
or
calling
Ms.
her. Yes, sir. I've got an alarm set at 6 p.m. every day.
Okay, so it's 6 p.m. And like I said, you can call Tuesday, Thursday. If she doesn't answer, Mom's not going to get in trouble for that. I just want her available on Mondays and Wednesdays.
Well,
But
That's understandable. You know, mom doesn't doesn't try to
Okay,
facilitate
Mr.
any
Mosley, stop
abuse
talking.
anyway.
Stop talking right now. Let the judge finish.
I don't want to, we're going to look, there's going to be a day where we're not limited in time for your final trial, and both sides are going to get an opportunity to tell me everything. I'm not going to be limiting it to just possession and access. So I'll address issues. If someone's doing something they shouldn't be doing, we're going to address that on the final trial. Mom, I can tell you this court always wants a mom and dad involved in a child's life. I understand there's safety concerns, and this court's concerned about that. But this is the least restrictive way, which is what the law requires me to do, to protect the child and make sure I'm maintaining a relationship between mom and dad, which means if he's calling his daughter and he's not getting to talk to his daughter, that's not something that's going to sit well with any family court judge, because we don't want a parent that doesn't want to foster a relationship with another parent. And
She
I'm
has
not
her
saying,
phone.
hold
He
on,
calls her on
hold
her
on, hold on. Hey, listen, y'all talked enough. Listen to me for now, both Mr. Mosley and Ms. Mosley. I'm not saying that's happening. I'm just letting you know that that's something that bothers the court. So if it is happening, stop it before the final trial, because if that's happening at final trial and there's evidence presented to me that proves that, that's going to be something that a court's not going to like. I'm not saying that what I'm admonishing Mr. Mosley of, calling it 10:18 at night, I'm not saying he's doing that. Ms. Mosley, I'm not saying that you're not letting him talk to his daughter. I'm just letting y'all both know those are two things that the court wouldn't like if that's actually happening. Okay, entry of the order is 10:15 of 21. The request for attorney's fees is from both sides. That's deferred until final trial. If you'd like to put that in the order, Ms. Pierce and Ms. Dent, you can do so. But that completes the ruling of the court. Anything that you think I failed to address, Ms. Pierce, that I needed to address, then I'll come to you next, Ms. Dent.
All other relief denied.
Not on a temporary order. I don't think there's really a need for that. It's not a final order, so anything can be presented at final trial. So I'm just,
Sure.
yeah, I'm just modifying what I modified today. Ms. Dent, anything further on your side?
Just instructions on when Mr. Mosley called, that the child is allowed to not have mom in the room over her shoulder while dad's talking to her.
So because of some of the evidence that I heard today about the language that's being used, I don't know if that's a fact or not, but I do know that there was evidence of that. So I'm not going to put a limitation on, because a lot of times I will restrict a mom or dad from monitoring the phone calls. A child cannot be themselves, especially when there's conflict between the mom and the dad. That child feels that conflict, whether you recognize that or not. So if dad calls and the child knows there's conflict between mom and dad, the child's not going to be comfortable showing that she loves dad, that she misses dad, that she has authentic feelings for dad, because she's thinking in the back of her mind that's going to disappoint my mom. So I normally don't like monitoring of phone calls, but because there were some allegations that there was strong language used towards the daughter, I'm not going to prohibit mom from being around the phone. But understand, on a final order, that is something that this court typically will do. So mom, try not to monitor the phone calls. Just understand that your daughter needs to be able to love and talk to her dad privately. If he's using abusive language with her, I expect you to protect her. But if he's not, and there's not a history of that, then just stay away from the phone calls. I'm already late for something else, so I'm going to let y'all go. We'll take anything else up on final trial. Entry is October 15th at 9 a.m. And y'all are excused. We're going off the record.
Thank you, Your Honor.
Thank you.